There is an ever-expanding intersection of educational policy and rule of law, and the conflicts that sometimes result. As a new school year begins, it is important to understand and appreciate the respective rights and obligations of students, parents, schools, and the criminal justice system. Attorney Shelley Freeland Eddy joins today's discussion with back-to-school basics that identify and illuminate particular issues as they may relate to your children and, most importantly, you as a parent.
The participation of residents in their local government is very important to the well-being of any community. Volunteer advisory boards and committees are a great opportunity for local governments to engage their citizens in the process of crafting policies and tackling issues. The City of Sarasota has over 25 advisory boards and committees with numerous opportunities for our citizens to volunteer their time and expertise, from Parks and Recreation to Public Art to the Historic Preservation Board, just to name a few. Many advisory boards require some experience in particular fields or professions, and some only require residency in the City of Sarasota. For more information on the City of Sarasota's advisory boards, visit sarasotafl.gov and click on the Government tab. There you can find a list of all city advisory boards and vacancies, and you can even download an application.
Good morning, Mayor Shelley.
Good morning, sir. How are you?
Good, thank you. I think we're going to ask you to put on your legal hat today.
Yes, sir. I did.
Attorney Shelley Freeland Eddy.
Yes.
We're just about a little more than a week away from the start of school in Sarasota County. What does our parents and students and families with children, with school-age children, what are your favorite things that they should know for a legal basis?
Okay. Well, when we get our children ready to go back to school, we think about our backpacks and school supplies and school clothes and new shoes, and sometimes I think we forget about arming them with information as they head back into the classroom. And what I look at from a legal perspective is making sure that our children are safe while they're on campus, and making sure that their rights are protected if they happen to come into contact with law enforcement, if they happen to be a victim of a crime, or if they happen to be accused of committing a crime while on school campus, on the school bus, or even during the school day, because there are some offenses where you don't have to be at school in order to be charged for committing a crime while in a school capacity. So I thought it would be helpful for us to talk to parents and youth groups and mentors, particularly about these are some things that we should be talking about as we send our children back to school. I think there is a misnomer that if an individual gets in trouble as a juvenile, that their record is automatically sealed and that it's sealed forever. And both of those are false.
Well, that's what the street attorney tells them.
Yes.
When they want them to do something wrong.
Right, right. That's true. Yeah, they make you think that, oh, it's fine, it'll go away, you don't have to worry about that, but don't listen to them. That's what this show is about. So, number one, as a juvenile, your offense, if it is a criminal offense, you can only have your record sealed until you turn 26. After reaching the age of 26, a juvenile record can be released, and it could expose you to some sanctions in your employment and professional entities, and so it's just really important. And so what I look at, and as a former prosecutor, you know, I would see juveniles come through our court system, and it would just bother me so bad that they were not armed with information, because the only things that people appeared to be concerned about was, is my child going to go to jail, and how much is it going to cost? Mm-hmm. And those things are a part of the conversation, but they are by no means the whole conversation. So I want to protect students' rights today.
Well, you know, you said something earlier when you first started sharing with us, that as long as they're in the school custody.
Right.
I remember a few years back, a youngster was getting off the bus at the bus stop.
Right.
And he picked up something from there in the bushes that was a toy gun,
Yep.
but they assumed it was a real gun.
Right.
And they told the school the next day, and they brought him to the office, but he still had that toy gun that he found. Mm-hmm. But the key was, my question to the school was, even if it was, and what you were told was that he got off the bus with all the other children and he saw something in the grass that should have been cut.
All right.
and picked it up, and it was a gun.
Mm-hmm.
And now you're talking about expelling him from school.
Right.
That was before we had the full investigation.
Right. Right.
So can you talk about that too?
Sure.
On the bus and
Right.
and getting off the bus?
Right. Well, there is a significant amount of latitude that schools have as it relates to children's rights, whether it be search and seizure, whether it be questioning, whether it be access to their personal things. You don't have the same rights as a youth at your school that you do at your home or at other places that are deemed to be private. On school campus, your backpack can be searched without probable cause. There's not a warrant that's necessary in order to search your items. Your person, given the right circumstances, could be searched by a school resource officer at the direction of a school, supervisor. On the bus is considered to be an extension of the school. So if the incident can be tied to the bus activity, there is argument that it could be tied. I would fight that. I mean, I wouldn't take that line down. We would go to trial on that one. But the point is that there's latitude, and particularly when it involves the alleged use of a weapon, and if that weapon is a firearm, because Sarasota County and multiple counties across the state have a zero tolerance policy of even possessing a firearm, let alone pointing it or firing it. And those preemptions are the same for juveniles as they are for adults. So the point is they have more latitude, and that we need to have different conversations with our children about what happens at school versus what happens in the privacy of our home, of our car, and of other places where normally there would be a search warrant. Two things that I want to particularly get across to parents is that when an individual is a juvenile and they get in trouble, there are a lot of options aside from a criminal conviction that can happen to a juvenile. A law enforcement officer can give a youth a warning and basically say, I'm going to make contact with your parent or your guardian and let them know that this issue happened, that these are the precautions, and that if it happens again, these are the sanctions. Or they could do something that's called civil citation. And civil citation is a program that is adopted by statute across the state of Florida that allows local municipalities to have less severe sanctions for juveniles, to where at the end of completing terms and conditions, they do not have a record. It's not a police report, it's a citation, and there are recommendations that are made to the Department of Juvenile Justice in Florida with regard to those sanctions. It keeps that young person's record clean. It's critical. However, it's not widely offered. You have to ask for it. That's our conversation here today.
Well, you say that it's widely accepted across the state of Florida.
Yes.
Does that mean every jurisdiction
Yes.
is in now?
Yes.
Because at one point in the legislature this year, I think that kind of bounced around a little bit.
Well, they tried to make it automatic under state statute, and Senator Roussan was a part of that effort, and apparently there wasn't enough support to get to the floor for a vote. So the automatic, where it goes through without a process, that still has not happened. There still is a review of the incident before it's referred to civil citation.
Well, that's why it's important that we have you here today.
Right.
Because a lot of folk who participated in, I know, this community through their churches and another organization
Yes.
to get that passed, thinks that it was passed.
Right, right. And you know, the thing is that, you know, Sarasota County has long offered the civil citation program, and you may not have heard civil citation, but you've heard of teen court. Yes. Teen Court here in Sarasota is the local agency that administers the civil citation program both for the Sarasota Sheriff's Office and for the Sarasota Police Department. So what happens is that if a young person has been accused of committing a criminal offense, which is called delinquency when they're under the age of majority, and a law enforcement officer elects to refer that person to civil citation program, they do have an appointment with a judge and they're placed into the program, and then teen court supervises them, and so long as they complete the terms and conditions, then it is a favorable approval and it never goes any further. What can you do? What charges can be used for this program? It's focused primarily on nonviolent misdemeanor and felony offenses that are not higher than the 3rd degree. However, under limited circumstances, if there are extenuating circumstances such as substance abuse or mental health complications, even those complications could allow a person that's committed maybe a violent offense who's never been in trouble before to go through civil citation. So what happens is that the police officer has to say, I think this person would be a good candidate for civil citation. They write it up. Teen court accepts it. They make contact with the parent or guardian. The guardian has an obligation of transporting the juvenile to the weekly meetings for teen court, ensuring that they complete the sanctions and that they stay drug and crime free, and also maintain appropriate school attendance while they're going through the program.
What is the age of majority in Florida?
18.
18?
Yes.
And you said a 3rd degree felony.
Right.
And explain that to us.
Well, felonies come in degrees, 1st, 2nd, and 3rd degree. 3rd degree is the lowest level felony. There are nonviolent 3rd degree offenses and there are violent 3rd degree offenses. The prevailing rule is that if it's a nonviolent felony of the 3rd degree, it will be accepted if there is violence, and violence could be a battery that had an injury, and the injury makes it not be a misdemeanor but get bumped up to the lowest degree of felony. Driving on a suspended license 3 times in 5 years is a 3rd degree felony in the state of Florida. So technically that would fall under one of those categories. So there's a list of charges and where a juvenile could be admitted. And here's the other misnomer that people will let you believe. If you've had one civil citation, you can't go through it again. That's not the law. The law is you can go through the program up to 3 times. 3 separate civil citations, you're still eligible to go through civil citation. And the point is creating an alternative to disposition so that an individual's criminal record can be protected. And more importantly for me in my role, that our youngsters can grow up and vote, that they can own firearms if they choose to, that they can get certificates of occupation for different fields within the state so that they can run for elected office, because a felony takes away all of those things. Even if the felony was committed as a juvenile, if it falls on the violent side. So this literally could stunt the growth of a generation if we allow things to happen. The other part of it is if civil citation doesn't work and it's not appropriate, there's another program that's called pretrial diversion. Pretrial diversion operates on a similar basis, except for it would be supervised by the local probation department as opposed to teen court. More serious sanctions, more reporting requirements, and the difference is too is that sometimes you have to pay a monthly supervision fee in order to be actively participating in the program. You can have those costs waived by the court, but the attorney that represents you has to request a waiver of those fees. The department will not consent to it because that's how they make their budget, is by folks who come through the program and pay their monthly fees. So they're not going to tell you, hey, if you're not working, you can have these fees waived because you're messing with my pocketbook. But you have the right to ask for it. One of the big things that I will say is that beyond that, you have the right to either have your record sealed or expunged in the state of Florida. For certain offenses as a juvenile, your record is sealed automatically. People assume that because I was a juvenile when I got in trouble, my record was automatically sealed. That's not correct. What it meant that while you were a juvenile, folks couldn't see your record. But then you turn 21, 25, and the huge job came, and you're ready for the promotion, and they look back and find that when you were 15, you had a felony as a minor. And they can see it now because it was never sealed. So there's a difference between a juvenile record not being seen and a juvenile record that is sealed.
One of the things you said that the police have a right to inspect your backpacks at school
Yes.
as a student.
Yes.
What instances, if there are any, as a student, you have to say, I want you to call my parents before we have this discussion? They get you, they take you to the principal's office.
Okay.
Because
Okay.
theoretically you've created some kind of problem to go there. And the school resource officer comes, or the school resource officer brings you. Are there instances when the child should ask for their parent?
Yes and no. We're mixing two different things. One is, does someone on campus think that your child committed a crime? That would be the probable cause analysis, which they don't have to meet that threshold on school campuses. There has to be a report that something has happened in order for law enforcement from a safety perspective to ensure the safety of the campus. So if that's the question, it could be someone brought a gun on campus, someone brought drugs to school, someone brought a bomb to school, someone did something, someone brought a knife, someone did something that makes our campus unsafe, and they have the higher authority of searching everybody to rule out whether or not those dangerous things are on campus. Can they do that without your parent being present? Absolutely, because you don't have the same rights of search and seizure as adults do, and you don't have those on campus. And even as an adult, when I go onto the school campus, there are some ways that I make myself vulnerable, not to that extent. The other part of the question that you asked me is that when should a child ask for their parent to be present? To me, that drifts over into if law enforcement wants to question my child about an incident, if they think that my child has committed a crime, what rights does my child have and what rights as a parent do I have? Here's the rule. If your child is in custody, then they have the right to have a parent present if they are under the age of 18. Here's the problem. Children don't know if they're in custody or not, and they don't know when to ask the question. So to me, people can be taken advantage of, but this is what I tell parents to tell their children, that if your child is asked to be questioned by law enforcement, then your child should do the following. Officer, am I under arrest? If the answer is yes, you don't ask for a parent, you ask for a lawyer. When you ask for a lawyer, they can't say anything to you. After you've asked for a lawyer, then you ask for your parent. If you say, officer, am I in custody? The answer is no. If I'm under arrest, the answer is no. The next question is, officer, am I in custody? In custody means I'm not free to leave. If they take you from the classroom or from the courtyard into a room and you are not free to leave, even though you're not in handcuffs, you are in custody for purposes of the law. And what that means is you have the right to counsel and to not answer questions at that point. So even if they say, no, you're not under arrest, because we don't know whether it's you and we're gathering information, then you still say, I'd like to speak with an attorney. That way they can't ask you any more questions. Then you tell that counselor, I'd like to speak with my parent. Please call them or allow me to call them. If you're not under arrest and you're not in custody, if you're not in custody, leave the room, go back to class and do what you need to do. If they tell you you can't leave, even though they said you're not in custody, you're in custody.
You're in custody.
Go back to number one. I'd like to speak with an attorney. I don't have anything else to say. Now, the point is to do this in a way that's respectful, that's civil, and that doesn't cause a conflict that gives them the ability to detain you for another reason because you caused a corruption and that you got out of control and maybe raised your voice and made some threats and blah, blah, blah. So these are the conversations that I think we're not having with our children. We talk about what to do if you're pulled over, but we don't talk about what happens if I'm at school and a police officer starts questioning me about something. Do I have rights? As a parent, can you come on campus if you find out that your child is being questioned? Absolutely. As a parent, can you assert your right as a parent to invoke your child's right to counsel? Yes, you can, and you should. If a detective comes to your door and has a question about something that has happened at school, then the parent asks the officer the same thing. Is my child being investigated as possibly being involved in a crime? Is my child in custody in any way? Is my child going to be placed under arrest? Is there a report for the pickup of my child? You have to ask those questions that way. And if they don't give you the no answers, then I'm invoking my child's right to counsel. My child is a minor. I have the right to have counsel present for them. and then you don't answer questions either, respectfully, because you don't know what they think your child has done. You don't know whether your child was present when one of their friends committed a crime. You don't know anything, but you know you need to protect your child's right to remain silent because they may have been involved. And it's a situation where we got to mitigate the damages and do the best thing that we can. So those are things that I don't think we talk about. But going back to the encounter, let's say we go through all of that and charges end up being filed, your child is a minor, and you get to the place where the state attorney's office offers you a plea to settle the disposition. And basically they say, you know, your child's never been in trouble, blah, blah, blah. I'm going to give you an adjudication and court costs. And you think that that's the greatest thing ever because you paid the $250 in court costs and your child is done. Absolutely not. Never, ever, 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 ever accept an adjudication of guilt as a minor, ever. And here's why. If you are adjudicated delinquent as a minor, you can never seal an adult offense in the state of Florida. So let's say you get a driving charge. You were driving without a license when you were 15. It was an adjudication and court cost, no big deal. And at age 25, something happens. You have been charged with a crime, and it's a felony. And you want to seal it. You can't seal that felony if you have a juvenile adjudication in your record. And parents just don't have a clue, and they don't understand why the law is so unfair. Well, I have theories about why it is the way that it is, but that's not what today is about. Today is about arming parents and mentors and youth groups with information.
You mentioned if the example was driving.
Right.
Our kids drive more than ever.
Yes.
To school, to athletic practice. And so that example you gave is for driving, period, while under the age.
Or driving beyond the scope of your permit. I mean, I don't know how many cases I've dealt with where juveniles have had driving permits or they're on restrictions, but they don't drive during the appropriate time, or they're driving after the hours, or they don't have a parent in the car, and technically they violated the law. Now that's a non-criminal infraction that goes to their driving record. But what happens is what if someone else is in the car and that person is doing something wrong, or that person has been in trouble, or that person may happen to have a controlled substance or something, and they're in the car with you, you end up being dragged into a police report, you know, by affiliation, you know.
Well, we got about 4 minutes left. I want to talk about college, grants, scholarships, and how does these, and drugs,
Right.
how does social media,
Right.
how does all of these things affect the college application or getting the scholarship?
Right. Well, I guess we'll start with drugs first. Drugs kill driver's licenses for many of our youth. If you are cited, whether you're arrested or not, for possession of marijuana, possession of a controlled substance, which could be cocaine, pills, or anything else, depending upon the level of the drug crime, your driver's license will be suspended at a minimum for a year. And what that means is that you have to spend money to take a driving course. You have to apply for a business purpose only license. It's a lot of time, a lot of expense, and a lot of headache to the family member that now has to drive you around everywhere because you got in trouble. Moving forward, with a drug conviction for certain offenses such as possession of a controlled substance that may be cocaine or other controlled substances, or trafficking or serious drug offenses, if you have even charges for those offenses and they were not convictions, it disqualifies you from applying for Pell Grants, for applying for certain applications, for admissions into the armed services, for many scholarship applications will ask, have you ever been arrested? Have you ever been convicted? Were you convicted of a misdemeanor, of a felony? Was the misdemeanor or a felony a violent felony? Was there a victim? Was there a restitution? Have you ever lost your right to drive in the state of Florida? And so those are things which all put together basically disqualify you from grants and aid and the ability to be able to afford to go to college. Let alone if you're an athlete, forget it, because of the rules that they have for, you know, athletics. And so it could really kill the destiny in terms of education. Moving forward to social media is another huge tool that colleges and universities use now I think almost 50% of colleges and universities that responded to surveys as to how they decide admissions indicate that in their application they ask for the username and password for your social media accounts, plural, and they list them all. Facebook, Twitter, Instagram, Snapchat, blah, 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 blah. And your failure to answer that question correctly, truthfully and completely, basically gets your application in file 13, which is the trash can. So number one, you've lied about the fact that you don't have accounts or you didn't disclose them all. And so what happens is that whether you answer that question yes or no, they pretty much think that you got something out there. So they're going to do their own Google search and find your Facebook pages, and they're going to look at your public pages and see what's out there. And what happens is that even if you haven't posted inappropriate pictures or messages and someone has tagged you to their page, then you still get that negative content.
So you need to know who you're dealing with on social media.
You need to know, and you need to scrub your pages. I recommend that minimum monthly, you should look at your pages and remove bad feeds and unfriend folks that are not in keeping with your vision, mission, goal of your life.
And your standards.
Absolutely.
Well, you're going to do this all over again for the community soon.
Yes.
Tell us about that.
All right. We have an event. My firm, the Freeland Law Group, has partnered with April Glasgow and Second Chance Last Opportunity and Pastor John Walker and Bethel CME Church. And we're going to do a community event on the first day of school, Monday, August the 14th at the Robert O. Taylor Community Center from 6 to 8 p.m. And we're going to discuss many of these issues and give parents, youth mentors a guide and tools to be able to be successful as they go back to school. So I provided you with a flyer, and you've committed to making sure that your viewers are able to see that.
Yeah.
It's free. We're going to be serving refreshments, and we're going to be giving out backpacks as well.
Well, thanks again for stopping by. We're going to have you back real soon.
Okay, thank you.